Welcome to the Phoenix Network, conceived to promote local spending at local small businesses, primarily by locals, by sharing the stories of local small business owners as told by the owners themselves. The Phoenix Network's goal is to keep more of each dollar spent locally, local. 30% more of every dollar spent locally stays within the local economy. In other words, local spending fosters as much economic independence as possible for Phoenix and the Valley. To do that, we apply principles of public relations, including this internet radio show, video of those stories as they're being told, uploaded to 5 video channels, and microspots from each of those story videos on each of 5 social media platforms. The Phoenix Network is sponsored by Local Motive Marketing, bringing the power of mobile technology to bear for local small businesses through geofencing, gamified mobile coupons, and business-branded Wi-Fi. To learn more, call 602-618-6626. Now, as you might know, we're going to do something a little different today. But before we get started, if you're experiencing feedback or echo, muting your mic, either phone or computer, should fix it, whichever one you're on. Now, there is a bill currently pending in the 116th Congress. It's already been passed by the House in October. And although already passed, you would only be familiar with it if you had seen a social media post about potential new requirements for corporations and LLCs. This bill, if enacted into law, would affect every business, but according to the Congressional Research Service, their summary says certain businesses, small businesses. So we feel like it's particularly going to affect local small businesses, and we're essentially donating today's broadcast as a public service to let local small businesses know about this, and for that reason we're focusing on this bill. Now, we've set up a call-in line for the Phoenix Network. The call-in line is 480-409-4103. That's 480-409-4103. Chat is available now at http://mixler.com/the-Phoenix-network. If you're listening on Mixler, you already see the chat box. Now, I make no promises about chat because this is the first time I've used that feature, and frankly, I'm not sure if I can field calls and chat at the same time I'm conveying vital information that, in my opinion, threatens every small local business. So we'll get as far as we can through the Corporate Transparency Act of 2019 in the hour scheduled. If necessary, we'll go long. We'll expand the show. Now, this bill is H.R. 2513, and it starts on page 1 as an act to ensure that persons who form corporations or limited liability companies in the United States disclose the beneficial owners of those corporations or limited liability companies in order to prevent wrongdoers from exploiting United States corporations and limited liability companies for criminal gain. To assist law enforcement in detecting, preventing, and punishing terrorism, money laundering, and other misconduct involving United States corporations and limited liability companies, and for other purposes. Now, there are feel-goods in this. First is insure. Insurance is a hot-button issue these days, and if politicians know anything, it's how to punch buttons. Prevent wrongdoers from exploiting. Now, who wouldn't want that? But what exactly do they mean by wrongdoers? There are obviously bad guys out there, no doubt. But if you sat 10 Americans down and asked them to each write a list of wrongdoers, you can bet that no 2 lists would be exactly the same. And as polarized as the country is at the moment, which is not that much different from the early days of the Republic, it's well within the realm of possibility that fur would fly, as the saying goes. Criminal gain. Now, there are few classes of people that don't disfavor criminal gain. I'll go out on a limb and I'll say those in favor are in fact criminals. Then we get to detecting, preventing, punishing, terrorism, money laundering. I am, as most of you probably are, all in on detecting, preventing, and punishing terrorism. But that's where those who are supposed to be the good guys have repeatedly come up short. There are other words in this string that raise the hairs on the back of my neck, and I'll call them the uh-ohs. First is disclose the beneficial owners of those corporations or limited liability companies. Next is to assist law enforcement. Then comes other misconduct, and worst of all, for other purposes, and for other purposes. Those terms and others in these 58 pages will come up from time to time as we go through this impending disaster. For now, we'll go over the text. Practically every public law enacted by Congress lays out findings. That is, the reasons, perhaps excuses is the better word, for the bill at issue. Again, we've set up a call-in line. Call-in number is 480-409-4103. We also have chat set up at http://mixlr.com/the-phoenix-network. Now, I'll keep up with fielding calls and responding to chat at the same time I'm conveying information as best I can. Section 2 is where Congress finds the following. Clause 1. Nearly 2 million corporations and limited liability companies are being formed under the laws of the states each year. Right there in Clause 1, a term comes up, and the phrase, the states, struck me as carefully worded. In fact, the word states, without the descriptive united, appears only 5 times in the entire bill. All of those are in Section 2. At clauses 1, 2, 7, twice, and 9. I'm sure this strikes you as meaningless, but the Supreme Court has stated many times that every word and phrase in a law is there for a specific reason. The phrase United States appears 10 times in Section 2. States only appears 5. And United States appears throughout this. There is a reason, maybe more than one, for the difference. We'll see if we can discover those as we go along. Clause 2 states, very few states require information about the beneficial owners of corporations and limited liabilities companies formed under their laws. Clause 3 states, a person forming a corporation or limited liability company within the United States typically provides less information at the time of incorporation than is needed to obtain a bank account or driver's license, and typically does not name a single beneficial owner. I told you this phrase was one of the primary reasons. That was one of the primary uh-ohs. One of the primary reasons that the concept of incorporation arose was privacy. No one should be able to peek into your finances. By giving a business venture a corpus, that is, a body, it became a person separate and distinct under the law from its own owners, its directors, its officers. Privacy. That was the main reason. But another reason was to avoid personal liability for the separate and distinct person's mistakes. In the time before incorporation was conceived, those concerns were addressed by the use of trusts under contract. But that's an issue for a different show that I'm planning on starting on this platform. It might mean I have to change the platform, the name, but we'll see. The Clause 2 and 3 findings show that Congress, or whoever drafted this bill, because we know they don't do this themselves, is disturbed by your privacy. Now, I'm going to provide a synopsis, In GovSpeak, government language, that's known as redacting of findings 4, 5, 6, and 9. I'm going to do that in the interest of time. Remember, questions, comments, and concerns are encouraged. The call-in number 480-409-4103. Chat is http://mixlr.com/the-phoenix-network. As a matter of notice, you might have to set up a free account to chat. I'll keep fielding calls and responding to chat as best I can, should they come in. Clause 4 states in part, and you're going to find this amazing, criminals have exploited state information procedures to conceal their identities, used them to commit crimes. That criminals conceal their identities and commit crimes should not come as a shock. It's what makes them criminals. Recall Clause 1. Does Congress, or whoever drafted this bill, think that all of the nearly 2 million corporations and liability companies formed each year is a criminal enterprise? If not, why should any presumably innocent person be subjected to this? Clause 4 continues, affecting interstate and international commerce. There's the rub. Right there, we see the only excuse for Congress, or whoever drafted this bill, could have for it. The Commerce Clause of the Constitution. Clause 4 goes on to identify the evils identified above and many more, including acts of foreign corruption. We've heard enough over the last few years about that, so we'll just move on. Clause 5. Law enforcement efforts to investigate corporations and limited liability companies suspected of committing crimes have been impeded. They've got, quote, reports and testimony by officials, unquote, to prove it. Is Congress, or whoever drafted this bill, saying that all of the nearly 2 million corporations and limited liability companies formed each year are suspected of committing crimes? Clause 6 explains that the leading international anti-money laundering standard-setting body, the Financial Action Task Force on Money Laundering, issued a report that criticizing the United States for failing to comply with its standard on the need to collect ownership information, and urged the United States to correct what it saw as a deficiency in July 2006. So 13 years ago, 13 and a half actually, the FATF issued another evaluation in 2008 that little progress has been made. And in another in December 2016, whined that this is, quote, a fundamental gap in the United States' efforts to combat money laundering and terrorist finance. Once again, the excuse for Congress, or whoever, in drafting this international crimes. That's the Commerce Clause. In response to the 2006 FATF report, the United States has urged the states to obtain beneficial ownership information for the corporations and limited liability companies formed under the laws of such states. Clause 8 says, in contrast to practices in the United States, all 28 countries in the European Union are required to have corporate registries that include beneficial ownership information. In other words, wait a second. Excuse me. The United States has been unable to coerce the states to comply with a request from other members of an international organization for 13 years. That's what Clause 7 says. After all, every one of 28 countries in the European Union are required. That's from Clause 8. That's just not fair. Clause 9. To reduce the vulnerability of the United States to wrongdoing. Mind you, this must be by the nearly 2 million corporations and limited liability companies formed each year that are clearly suspected of committing crimes. Federal legislation is required to require states to protect interstate and international commerce, to strengthen law enforcement investigations, to set a clear, universal standard for state and corporation practices, and to bring the United States into compliance with international anti-money laundering standards. Let me tell you something, folks. To protect interstate and interstate commerce is strictly their job, not the states. And to bring the United States into compliance with international standards, that's just a crying shame. In other words, though, the United States, the only semi-constitutional way to coerce the states to comply with a request from other members of an international organization is if all of the nearly 2 million corporations and limited liability companies formed each year are in fact suspected of committing crimes. Does that feel better? Now remember, questions, comments, and concerns are encouraged. The call-in number 480-409-4103, and chat is found at http://mixlr.com/The Phoenix Network, THE-Phoenix-Network. And again, you might have to set up a free account to chat. As well, I'll be keeping up with calls and responding to chat as much as I can. Section 3 is when it gets really bad. But here's where it also gets good. Titled Transparent Incorporation Practices. Paragraph 1 amends the Bank Secrecy Act and adds a new section. Section 5333. And bears that title. Transparent Incorporation Practices. Here's where the specter and other purposes first arises. Most Americans are less than familiar with the Bank Secrecy Act. So here's a reminder. The Bank Secrecy Act was, quote, aimed toward preventing criminals from using financial institutions to hide or launder money. The law requires financial institutions to provide documentation to regulators whenever their clients deal with suspicious cash transactions involving sums over $10,000. It was enacted in 1970. It was intended to target the mob for gambling, for prostitution. Now, the horror stories you might have heard about IRS simply seizing the accounts of small business owners have their origin in the Bank Secrecy Act. Whatever's in the Internal Revenue Code came along after that. The Bank Secrecy Act, or the regulations it authorizes, have been amended to the point where simply depositing cash, any amount of cash, into your bank account now requires you to produce identification. Depositing cash is apparently a suspect activity because, after all, only criminals deal in cash. It's also, by amendment, included in the Uniting and Strengthening America by providing appropriate tools and resources to reduce, interdict, and obstruct terrorism act it's required to impose know your customer procedures. That amendment, inserting a new section, the new amendment for today's issue, the new section 5333, runs from page 3 nearly all the way through page 15. It requires that each applicant to form a corporation or limited liability company under the laws of a state or an Indian tribe shall file a report with FinCEN. That's the Financial Crimes Enforcement Network, coincidentally created by a 1990 amendment to the Bank Secrecy Act. Required to file a report with FinCEN containing a list of the beneficial owners of the corporation or limited liability company. Now, didn't they say in the findings, I believe it was Clause 2, that applicants for, or persons starting, corporations or limited liability companies in the states typically had to present less information than typically required to open a bank account and obtain a driver's license? Well, the last time that the Bank Secrecy Act was amended, that I know of, was when the Uniting and Strengthening America by providing appropriate tools and resources to reduce, interdict, and obstruct terrorism act was enacted in October of 2001. So, don't they already have the information? Now, I'm talking specifically about FinCEN here. Doesn't FinCEN already have the information through the Know Your Customer regulations in the Bank Secrecy Act that came out of the USA Patriot Act, which pretty much eliminates the need for this? It requires, though, the report to identify each beneficial owner by full legal name, date of birth, current residential or business street address, and a unique identifying number from a non-expired passport issued by the United States, a non-expired personal identification card, or a non-expired driver's license issued by a state, and, if the applicant is not a beneficial owner, also provides the identification information described in the first clause relating to such applicant. Let's back up. Didn't the amendment to the Bank Secrecy Act that created the Financial Crimes Enforcement Network impose Know Your Customer rules? Did that not solve the problem of typically don't have to give any more information or as much information as required to get a bank account? How is that problem, assuming there is one, solved by requiring not only name, date of birth, current residential or business address, and unique identifying number from a non-expired driver's license issued by a state? A solution for that. They already have the information. the banks already have to require that information to give it to FinCEN. Under the Know Your Customer regulations that were created by FinCEN in the Bank Secrecy Act as a result of the USA Patriot Act. Now, it also requires each state to notify each applicant of these requirements, because obviously a state requiring information in order to get a driver's license isn't strong enough. They have to also notify you of these requirements under this new amendment to the Bank Secrecy Act. It also requires applicants, beneficial owners, or similar agents, like a registered agent, an agent for service of process, etc., who doesn't have a non-expired passport, personal identification number, or a driver's license, to provide FinCEN, this is going to get technical here, the full legal name, current residential or business street address, a unique identifying number from a non-expired passport issued by a foreign government, and a legible and credible copy of the pages of a non-expired passport issued by the government of a foreign country bearing a photograph, date of birth, and unique identifying information for each beneficial owner. There's more. Each update, because, by the way, if you're not starting a corporation, if you have an existing corporation or limited liability company, you're going to have to do this stuff too with an update. Each update shall include a written certification by a person residing in the state or Indian country under the jurisdiction of the Indian tribe forming the entity that the applicant, corporation, or limited liability company has obtained the same information for each such beneficial owner. Has to verify that they have verified that the full legal name, address, and identity, and will provide the information and the proof of verification upon request of FinCEN, and will retain the information and proof of verification for 5 years after the corporation or limited liability company terminates. Now, once again, let's go back to will provide the information and verification upon request of FinCEN. This is the information that FinCEN already has. If there's a bank account in this country, and if there's not a bank account in this country, what is the link to interstate commerce? What is the link between the United States and any other country in international commerce? When you start looking at these things, this is why they write them the way they write them. They want them to be confusing. I once read an article by a gentleman, an American with a Mexican wife, that had a bilingual household. This was well before the movie Spanglish came out. And he appreciated the precision of English. English is the most precise language in the world. At the time, it had less than 500,000 words in the English lexicon. That has expanded greatly at this time. But he appreciated the romance and the passion of Spanish. So each language has its own particular benefits and features. Now, the only exemptions are for corporations and limited liability companies that are already licensed by a federal regulator, meaning the banks already have the information, the regulators already have the information, and that's stated in subsection D4C of the amendment. And we're going to get a little bit more technical here. I can't redact much of this. The other exemption for corporations and limited liability companies is that individual business concern or class of business concerns which the Secretary of the Treasury and the Attorney General of the United States have jointly determined to be exempt, and if the Secretary and the Attorney General jointly determine that requiring beneficial ownership information from the business concern would not, in fact, let's see, where is it? I got lost here. Would not serve the public interest and would not assist law enforcement efforts to detect, prevent, or prosecute terrorism, money laundering, tax evasion, or other misconduct. I'm going to read that again so I don't get lost again. An exemption applies to individual business concern or class of business concerns which the Secretary of the Treasury and the Attorney General of the United States have jointly determined to be exempt. If the Secretary and the Attorney General jointly determine that requiring beneficial ownership information from the business concern would not serve the public interest and would not assist law enforcement efforts to detect, prevent, or prosecute terrorism, money laundering, tax evasion, or other misconduct. What are the odds that will happen? So you see, as we go through this, you can pick out, at least once you've gotten a little bit of education about the matter, you can learn to read the law. You really can, folks. It's not that hard. Okay? The hardest part is accepting that you can. I'm not saying it's not work. I'm not saying it won't be a challenge at first. But once you learn it, you can take a paragraph-long sentence. You can break it into... You remember in school how you learned how to do an outline of a sentence? You can do an outline of any paragraph-long sentence, and you can break it down into its component parts and understand it. And once you have done that a few times, you can do it without having to physically go through and create an outline structure. You will know when you're reading that paragraph-long sentence exactly what it says, and you'll have to get into the definitions that are found in every body of law to understand what it says. The meanings. But you can understand the words, and you can understand the law itself on its face just by going through that exercise of learning how to break it down into outline form. Now, since we didn't get any calls and we didn't get any chats, I have time left, which is fortunate because moving on, this bill, H.R. 2513, also creates the Counter Act of 2019. Let's think about that one for a minute. The Counter Act. 2 words, not one. It's Counter Act, not counteract. Okay? The Counter Act of 2019. In subsection A, it says This act may be cited as the Coordinating Oversight, Upgrading, and Innovating Technology and Examiner Reform Act of 2019, or the Counter Act of 2019. Remember the Uniting and Strengthening America by Providing Appropriate Tools and Resources to Reduce, Interdict, and Obstruct Terrorism Act? I can only imagine how many chiropractic bills arose out of the twists and turns it took to come up with the acronym USA Patriot Act. That must have hurt. And now we've got the Coordinating Oversight, Upgrading, and Innovating Technology and Examiner Reform Act of 2019, or the Counter Act of 2019. The point in bringing all of this up is that politicians are inherently incapable of honesty. The Counter Act also amends the Bank Secrecy Act to include the Counter Act of 2019 in its definition in 31 U.S.C. 5312. That's Title 31, United States Code, Section 5312. It inserts, to protect our national security, to safeguard the integrity of the international financial system, and before to require. Let me say that again, because the way they do this part's written exactly as they did. Inserts, quote, to protect our national security, safeguard the integrity of the international financial system, and, unquote, before, quote, to require, unquote, in Title 31 United States Code, Section 5311. Also there, it inserts, quote, to law enforcement and, unquote, before in criminal, unquote. Here's the best part, folks. Excuse me. I saw this. Sorry, I find this hard to swallow. The Counter Act of 2019 creates a civil liberties and privacy officer position within each federal functional regulator. Remember the regulators that are exempt from the Corporate Transparency Act? Okay. It creates a position, civil liberties and privacy officer, within each federal functional regulator, within the Financial Crimes Enforcement Network, by the Secretary of Treasury, and within the Internal Revenue Service, Small Business and Self-Employed Tax Center. Once again, it creates a, quote, civil liberties and privacy officer, unquote, position within each federal functional regulator, within the Financial Crimes Enforcement Network, under the authority of the Secretary of the Treasury, and within the Internal Revenue Service, Small Business and Self-Employed Tax Center. Because we know how much they all respect civil liberties and privacy, right? Especially the IRS. They just, you bring up civil liberties and privacy to IRS, and they just bow down before you. Right. Now, this is a quote, each civil liberties and privacy officer shall be consulted on information sharing programs, including those that provide access to personally identifiable information. Ensure coordination and clarity between anti-money laundering, civil liberties, and privacy regulations. contribute to the evaluation and regulation of new technologies that may strengthen data privacy and the protection of personally identifiable information collected by each federal function regulator, and develop metrics of program success. That's what each civil liberties and privacy officer shall do. There's also, and this is another one you're going to love. You got to love this. There's also a Civil Liberties and Privacy Council, quote, which shall consist of the civil liberties and privacy officers. Civil Liberties and Privacy Council, quote, which shall consist of the civil liberties and privacy officers. It also creates that and says the director of FinCEN shall serve as the chair. And remember, and also there's the International Coordination, the International Monetary Fund, and FinCEN Domestic Relations or Domestic Liaisons are created in this Counter Act of 2019. So I hadn't yet done a search on how many times FinCEN appears, and I'm not going to try to do it now, because that would actually take, well, it would fill up the rest of the time I have for the hour. But I'm not going to keep it going that long if you don't have it and you don't want it. Okay? The point is this, okay? Based on the findings of Congress that are essentially that nearly all of the 2 million corporations and limited liability companies that are being formed under the laws of the states each year are in fact suspected of committing crimes. Okay? Now, that's what it breaks down to in the findings. And because nearly all 2 million of the corporations and limited liability companies formed in the states each year, okay, are in fact suspected of criminal activity, suspected of committing crimes, it's required that the Bank Secrecy Act be amended to include a new Section 5333 that basically requires each applicant. Notice it's no longer a person. Now, you may know that in law, person doesn't necessarily include a human being. But now, person has been changed to applicant. Each applicant to form a corporation or limited liability under the laws of a state or Indian tribe shall file a report with FinCEN, the Financial Crimes Enforcement Network, the same organization that was created by another amendment to the Bank Secrecy Act in 1990 to go after the mob. Okay. Now, they're required to file a report with FinCEN containing a list of the beneficial owners of the corporation or limited liability company. That includes the full legal name, the date of birth, the current residential or business street address, and a unique identifying number from a non-expired passport issued by the United States or by a foreign government, for that matter, by a non-expired personal identification card or a non-expired driver's license issued by a state, and if the applicant is not a beneficial owner, also provides the identification described in Clause 1 above, relating to such applicant. So, that brings us to persons who form. If it's not yours, if you're not a beneficial owner, who forms corporations? Who forms LLCs? Normally that would be an attorney, wouldn't you think? Sometimes you might have a paralegal like myself actually form a corporation or LLC for you, which is simply a matter of drafting paper. Now, the only time that a corporation really needs to get complicated is possibly, maybe, when somebody wants it to be so convoluted that they actually are trying to hide what they're doing. That's possible. And in that case, they'd want an attorney who are somewhere below used car salesmen in terms of reputation. Now, I have met a lot of attorneys. I have faced off with a number of them. I've met a handful I actually liked. There's really not one that I would trust my life and my freedom to. Not ever. Because most people don't know this, but an attorney's first obligation, and this is more properly subject matter for that other show that I talked about that I'm planning on starting, but I have time to fill here. Attorneys are officers of the court. As an officer of the court, their primary obligation is to the court that they're an officer of. Their secondary obligation, according to the legal encyclopedias, is to the public. Doesn't say so, but I'm assuming that's because the public is who the court is supposed to be there to serve. And they say the third obligation is to the client. Now, of course, that doesn't actually address the issue that as an officer of the court, with its primary obligation to the court, there are brother and sister officers of the court, which one would think probably come in before even the public, and certainly before the client, who comes in third position at best. Okay? Now, by the way, if that applicant doesn't have a U.S. passport or state driver's license, state personal identification card, that's where they have to come up with the passport number from a foreign government, along with a legible, credible copy of the passport, and include all pages. Picture, date of birth, unique identifying information. Each update shall include the same stuff. Okay, and that the state or foreign country or Indian country, tribe, has in each update they have to certify, have to file a report, a certification by a person residing that it has obtained the same information, has verified the full legal name, address, and identity, and will provide the information to FinCEN upon request of FinCEN. Now, they also have to retain the information and proof of verification for 5 years after the corporation or limited liability company terminates. Got that? You go into business with a corporation or limited liability company for whatever reason, hopefully good. You terminate the business. you're done. You've gotten what you've gotten, or you've crashed and burned. 5 years is how long after either of those occurrences that they have to retain the information and proof of verification. Now, it appears that only applies to, foreigners that are creating corporations and limited liability companies under the laws of the states. But don't forget my most troubling, and for other purposes. Remember, the Bank Secrecy Act originated to go after the mob. That's all it was for. But, and for other purposes, have allowed it to be used against God knows how many businesses, how many people. The Racketeer Influenced Corrupt Organizations Act, the RICO Act, same thing, created to go after the mob. Racketeer, duh. Racketeer Influenced and Corporate Operations Act, the RICO. Okay, organizations, that's what it was. Racketeer Influenced Corrupt Organizations Act. At this point, RICO can be used and has been used against almost everybody. In fact, I don't know whether it was by amendment or not, but it's actually possible, federal and state, to bring a private RICO action in a private lawsuit. You got to notify the government, whichever, that you're bringing a private RICO action to give them the opportunity to step in if they want to. That's a 50-50 shot. But the fact is, you can file a RICO lawsuit privately. It's written in the law. The law that you can read. The law that you can understand. And the law that basically you can learn to understand if you simply learn to break down that sentence, paragraph-long sentence, into an outline form. That makes it understandable. And once it's understandable, you can read the next one straight through without even having to worry about whether or not it's in outline form. One last point, because we're getting within 8 minutes of the show ending. There are exemptions to the Corporate Transparency Act of 2019. Okay. Now, the exemptions are if you're licensed by a federal regulator already. Well, duh. FinCEN's already got that information because the SEC or the Board of Governors of the Federal Reserve or whatever government entity actually licenses that federal regulator already has the information. Gee whiz, isn't that nice of them to give you an exemption there? Okay. The other exemption, there's only two, is that if the Secretary of the Treasury and the Attorney General, this is with respect to individual business concerns or class of business concerns, if they have jointly determined those to be exempt, and if the Secretary of the Treasury and the Attorney General jointly determine that requiring beneficial ownership information from the business concern would not serve the public interest and would not assist law enforcement efforts to detect, prevent, or prosecute terrorism, money laundering, tax evasion, or other misconduct. Remember, folks, the only authority that Congress has to pass laws that are in effect within the states is under the Commerce Clause. Okay? Otherwise, they're separate entities. They're individuals. Interstate brings in federal jurisdiction. International theoretically brings in federal jurisdiction, although they've kind of waived that considering the Arizona-Sonora partnership and others that are just like it. Okay, I'm not picking on Arizona, I'm not picking on Sonora, I love them both. Okay, the bottom line is that you need to know about this, and so I donated this, going on 58 minutes now, to tell you about it. Okay? Once again, this is the Phoenix Network. And it was conceived to promote local spending at local small businesses, primarily by locals, by sharing the stories of local small business owners as told by the owners themselves. The Phoenix Network's goal is to keep more of each dollar spent locally, local. 30% of every dollar spent locally stays within the local economy. And local spending fosters as much economic independence as possible for Phoenix and the Valley of the Sun. We apply public relations principles to do that. This internet radio show, video of the stories as they're being told, uploaded to 5 video channels. Microspots from each of those story videos on 5 social media platforms. Each of those story videos on each of those platforms. The Phoenix Network is sponsored by Local Motive Marketing, bringing the power of mobile marketing technology to bear for local small businesses through geofencing, gamified mobile coupons, and business-branded Wi-Fi. To learn more about either one, call 602-618-6626. Have a great weekend, folks. We'll see you next week.